Advocate Smenya.
Judge President and Justice, regarding the question whether there were any factual findings made.
Yes.
The court will recall that Advocate Mpofu, as well as Advocate Nukai Toby, they made the point that there were certain factual findings which were made by the Public Protector. Might I invite the court to go to page 62 of the pleadings bundle? There we find the affidavit of the Public Protector, which addresses that very specific issue. She says against paragraph 12, I do not summarize the contents of the report in detail. The following features are relevant for the purpose of this application. 12.1, she says, the report does not contain findings of fact. And she has not been contradicted on that point. So we belabored the argument yesterday in trying to demonstrate what factual findings were made in the report. And we are told in very express terms by the Public Protector that that report does not contain any factual findings. Instead, it sets out the evidence that the Public Protector gathered during her investigation. 12.2, she says, one reason why the report does not contain factual findings is that the Public Protector was unable to interview all the relevant parties before concluding the report. So she's also telling us the second reason why that report cannot be a report within the meaning of the Constitution, because it certainly did not interview all the relevant parties before concluding the report. She continues, the Public Protector states, for example, that there are relevant persons that she has yet to interview. That's another reason why there cannot be any factual reports or factual findings in the report. Although she makes no conclusive findings of fact, that's what she says against paragraph 12.3 on the same page. The observations are stated in the language of a prima facie or provisional findings. Now we will remember that the Public Protector in the report does not talk about anything prima facie. This is her account about what she considers observations to be. Now, observations and prima facie proof are two distinct and different concepts in law. The Public Protector says that aspects of the President's conduct are worrying, that if the evidence she has received is accurate, then the President may have breached the provisions of various statutes, and that the failure to take steps in regard to various allegations is a source of concern. Over the page 63, then she deals with why the investigation is divided into two phases. Against paragraph 12.5, she says, for example, the report says that the issue of whether any state functionary or any other person acted unlawfully, improperly, or corruptly in connection with exchange of gifts in relation to the Gupta-linked companies or persons, then open quotes, will be attended to further in the next phase of the investigation. 12.6, this envisages that the Commission will continue and finalize the investigation into matters in respect of which the report makes provisional findings. And 12.7 says the issues that have been expressly reserved for the next phase of the investigations are, and she tabulates them. Our submissions in that regard was that it is common cause that the report contains no factual findings at all. The next point we wish to make is probably the more pointed one. Justices, this case has nothing but nothing to do with the propriety or otherwise of the conduct of the president. Absolutely nothing to do with his conduct. We are not facing, yes, this application does not implicate anything that the president has done, whether it is good or bad, whether it was wayward or not. It absolutely has nothing to do with it. It also has absolutely nothing to do with whether or not objective factors are present, which factors would impel that the president must exercise the power he has under Section 84. There is no such an application before you. So when the respondents are saying to the court, the president must be told to do exactly what he has undertaken to do, there is no such an application. The application to compel that the president must implement the remedial action was one that served before Judge Makume. And that application failed. So we're not repeating ourselves here. And it is important that we describe what is the nature of the question this court is being invited to address. And this is it. This is a review application. It is an application to review whether the public protector can do what he has done. And we have at length been inviting the respondents, all of them. Please locate the power in the Constitution or law which says the public protector can take an investigation which is in her office, decide that that investigation must be done, one, by the commission. The next question is, please locate for us a source of law, either in the Constitution or elsewhere, which says the public protector has the power to push beyond the boundaries of separation of powers and dictate to the executive that the executive must exercise an executive power which resides solely with the president. Those are the issues before this court. Now, Judge President, you asked the question, did she do what she is constitutionally obliged to do? And there was no answer to that question, because you know she didn't. Instead, she says, I want this investigation to be done elsewhere. Now, for the elsewhere, we want to say, please give us the power in law that authorizes that to happen. And we must dispel another argument with respect, Judge President and Justices. We are not making a case that a remedial action is not wide or should not be effective, or that a commission can be the best suited vehicle to do the investigation. That's not why we're here. We're saying as wide as those powers are, as effective as they should be, does the wideness and the effectiveness entail her going beyond the powers and go and intrude into the province of the executive? That's the question you're asking. Now let us look at what sources of law have been offered for this question. Firstly, we are told we should go look at section 6, bracket 4, bracket C, Roman figure 1. Can I invite the court that we do that? That is the Public Protector Act. The section reads, at a time prior to, during or after an investigation, if he or she deems it advisable to refer any matter which has a bearing on an investigation to the appropriate public body or authority, we say, just at that level, that is not a power to take any part of the investigation to be conducted by an entity like a commission of inquiry, or even worse, to dictate to the executive what executive power the president must exercise. And it continues, if he or she is of the opinion that facts disclose the commission of an offense by any person, to bring the matter to the notice of the relevant authority and charge with the prosecutions. We remember when you look at the remedial action taken, there are specific entities there which are set. They must go and investigate the NPA and the Hawks. That she can do. But that is not an authority for her to take an investigation out of the Public Protector's Office, and also to tell the president must exercise a particular power. To that was added another section of the Public Protector, and this is my learned colleague, Mr. Badlander, says, please include in there section 6(4)(b). Well, we can go there again, my lord. That section reads, the Public Protector shall be competent to endeavor in his or her sole discretion to resolve any dispute. If I stop there and ask, if you say the president must appoint a commission, are you resolving any dispute? Or rectify any act or omission? Is an appointment of a commission of inquiry something that would rectify any act or any omission? Then we can live by mediation. That's not where she's going. We can leave conciliation or negotiation. She's not going there. Advising where necessary any complainant regarding appropriate remedies. That's not where she is. Or any other means that may be expedient in the circumstances. And this is offered as an authority or a legal basis why she would have the power. Why she would have the power that an investigation in an office must be done elsewhere.
The reason I have to, I'm losing. Does anybody have a clear copy of this?
I'm told it's in the bundle of the DA at page 2.
All right.
I don't know what the deal bundle is.
Yes, I have it. Would you mind, just for my convenience, just repeat the sections that you are, the section numbers, so I can just underline them.
Okay. May I start with section 6(4).
Right.
C, Roman figure 1.
Yes.
If we go to 6(4)(c), Roman figure 1, it would tell us that at a time prior to, during, or after an investigation, if he or she is of the opinion that facts disclose the commission of an offense by any person, to bring the matter to the notice of the relevant authority and charge with the prosecutions. Now, can I invite us to go and look at page 354 of the record? At that page, we find paragraph 8.11 of the remedial action. There, the public protector is very express where she sources the power to make that remedial action. She says, the public protector, in terms of section 6.4c, Roman figure 1 of the Public Protector Act, brings to the notice of the National Prosecuting Authority and the DPCI those matters identified in this report where it appears crimes have been committed. So she's conscious to point to the source of authority for that remedial action. When we go to paragraph 8.4, which is the impugned paragraph, she does not claim to have any authority for that remedial action, that the president must appoint a commission of inquiry. There she is citing no authority under the Public Protectors Act. And it is that authority that this application is looking for. Well, we know it is not that section now. The other section which is offered, at least by Mr. Badlander, is section 6.4b. Again, let us go see whether 6.4b does that. And as I read it earlier, the public protector shall be competent to endeavor in his or her sole discretion to resolve any dispute. Is this what she's doing? Saying the president must appoint a commission of inquiry. Is she resolving any dispute? And it would be a dispute between who and who? Or to rectify any act or omission. Which act or omission does she rectify by paragraph 8.4? And then we are told it is any other means that may be expedient in the circumstances. She does not even claim this to be the basis of her authority. That I've considered it more expedient in the circumstances to outsource the obligation she has under the, yes.
When you look at the argument that I gathered from the 6th respondent was that when you look at 4B3, you read it in conjunction with 4A. So what is she bound to investigate? And one of those at 5 is acts or omission by persons employed by government at any level. And the way I gather the argument, that ties in with how the remedial fits in with 4B3.
Justice Hughes, let us go there and see how 4A and Roman figure 5 would tell us. The public protector shall be competent to investigate on his or her own initiative or on receipt of a complaint any alleged, and then they tabulate the whole host of them and says, will be competent to investigate any act or omission. There is no debate that she has that power. By a person in the employ of the government at any level, we accept she has that power. Or a person performing a public function, we also accept that is correct, which results in unlawful or improper prejudice to any other person. We accept that is the power she has. But the remedial action does something different. It says, because for want of resources, I am going to take this investigation out of my office. And then I'm going to instruct the president what executive power the president must exercise. And exercise that power by making the investigation to be conducted by the commission. Let us get a little concrete and see and examine one complaint. The complaint relates to the Executive Members Ethics Act, to say there's a breach of the Code of Conduct. Now let us go to Section 3 And let us read in there what Parliament says must happen in relation to such an investigation. It reads, the Public Protector must investigate any alleged breach of the Code of Ethics on receipt of a complaint contemplated in Section 4. Now, Parliament says it is the Public Protector who must do it. And then says the Public Protector must submit a report on the alleged breach of the Code of Ethics within 30 days of the receipt of the complaint. And 2A says, 32A then says, to the President, if the complaint is alleged against a cabinet member, that's not relevant. B is also not relevant. 3 then says, if the Public Protector reports at the end of the period referred to in subsection 2, that investigation has not yet been completed, the Public Protector must submit another report when the investigation has been completed. So we know what she's supposed to do in terms of this act. And then prescribes a process what must happen with that report going forward. Now,
Don't stop there. Sorry, Mr.
okay.
Salini. Now let's look at 4. When conducting an investigation in terms of this section, the Public Protector has all the powers vested in the Public Protector in terms of the Public Protector Act 1994. Now that blends in now back to 6.4.
Well, all that section says is if you are acting under the Ethics Act, you still retain the powers that you have under the Public Protectors Act. So we must go to the Public Protector Act and see where does the source lie in the Public Protectors Act. That says she can then take an investigation of this kind and place it before a commission for investigation and report. Where does that power come from? We say it certainly does not come from that provision. That provision only tells us one thing. When you do that investigation under this act, you are not losing any of the powers that you have in terms of the Public Protectors Act. So we can get rid of that as a basis of authority for what she's doing. The other attempt at showing us any authority the Public Protector has, we are told we must go look at Section 8, bracket 1 of the Public Protectors Act. Well, let us go there. The section reads, the Public Protector may, subject to the provisions of subsection 3, in the manner he or she deems fit, make known to any person any findings, point of view, or recommendation in respect of a matter investigated by him or her. Mr. Ngugai Toby says we must go look at that to see whether this is sufficient authority for the proposition that she has acquired now the right. When Parliament says she must investigate the breach of Code of Ethics, we are told that Section 8.1 would authorize that to happen. Clearly not. What 8 is dealing with is that she can make known to any person any finding, point of view, or recommendation. It has nothing to do with the power that we are saying the Public Protector does not have. Another attempt at pointing us to any source of law for what she is doing, we are told we must go look at Section 7.3 of the Public Protectors Act. Again, I invite the court that we go there. This is how that section reads. The Public Protector may, at any time prior to or during an investigation, request any person at any level of government, subject to any law governing the terms and conditions of employment of such a person. So that can be the source of law under this Act, empowering the Public Protector to take an investigation in the office and go and plant it elsewhere, but worse. Then say the president must act as she directs, dictates, and will address that point. 2, she can do that at any stage and request the person performing a public function, subject to any law governing the terms and conditions of the appointment of such a person. That clearly is not authority for this. 3, a person otherwise subject to the jurisdiction of the public protector. A commission of inquiry is again not such an animal. So we can delete as a basis of any authority that Section 7.3 gives it the power to delegate as is contended for. If you understood the argument again, is that that power is clearly within her remit if one looks at Section 181(2) of the Constitution. We are told, let us go and look at 182(1), which reads, the public protector has the power, as regulated by national legislation, to investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged or suspected to be improper or to result in any impropriety or prejudice, to report on that conduct and to take appropriate remedial action. There is no contestation in these proceedings that those are the powers that public protector has. The question is, how far are those powers permissible? How far can a remedial action be permissible in law? Because why? She too is subject to the Constitution and the law. Now, Section 181, sub 2 will tell us when it refers to this independent Chapter 9 institutions. It says, these institutions are independent and subject only to the Constitution and the law, and they must be impartial and must exercise their powers and perform their functions without fear, favor, or prejudice. Now we know, if she's subject to the Constitution, it must mean that Section 1C of the Constitution applies to her. And that section tells us the rule of law is one of those values of the Constitution. And that also tells us the rule of law has one of its tenets, the separation of powers. So she can't straddle arms of government because she has the power in the remedial action. But let us see what the Constitutional Court has said in relation to that. The UDM judgment is in the bundle of authorities at page 521. At the foot of the page, we find where the court is dealing with the remedy under paragraph 92. There the Constitutional Court says, this court has been asked to direct the Speaker, and I wish to emphasize the word direct. This court has been asked to direct the Speaker, in quotes, to make all the necessary arrangements to ensure that the motion of no confidence is decided by secret ballot including designating a new date for the motion to be debated, close quote. Then says the court, but no legal basis exists for that radical and separation of powers insensitive move. So, however wide her powers can be, says the Constitutional Court, they don't include such a radical thing as to direct what the Speaker must do. And the remedial action, as to use the language of my learned colleague, Mr. Badlander, requires it to happen and uses the word, it forces her to happen, to do it. But what is the authority that the public protector has that enables her to force the executive to do something? Now, we are told that there are a number of instances where she has done it in the past. But that can be authority in law for that proposition. It's just simply that she has not been taken to court to review what she's not in law entitled to do. So if she has been doing it happily and widely, that can be a source in law for her to do it this time. She must derive that authority from law or the Constitution. In paragraph 69 on page 519 of the authorities, the same judgment, the court has made this point. Our decision that the power to prescribe the voting procedure in a motion of no confidence reposes in the Speaker accords with the dictates of separation of powers. It affirms the functional independence of Parliament to freely exercise its Section 57 powers. Now we can substitute for that and read our decision that the President has the power to appoint the Commission resides with him and with him alone. So there is already a court that says these powers of the Public Protector may be very wide. They may include effective remedial powers, but it must derive from a source in law. To buttress that point, we refer the court now to the Reserve Bank judgment, and in particular to deal with which appears on page 502 of the bundle of authorities, and paragraph 41 in particular. At the same time, we are addressing this point that the Public Protector has more powers than courts of law. I mean, that is very startling. The courts of law, the Public Protector, and everybody else is bound by the Constitution. And when it says don't breach the separation of power unless you are mandated to do it, and the courts are mandated to do it in circumstances of 172, the source of that intrusion is authorized by the Constitution. So the Public Protector must point to us. What authorizes her to trespass on the province of the other spheres of government? The judgment reads as follows. As I understand it, the Speaker's argument besides challenging the rationality of the remedial action rests on a proper interpretation of the powers of the Public Protector under Section 182(1) of the Constitution. Section 182(1)(a) gives the Public Protector power to investigate improper conduct. in state affairs or in public administration. Section 182(1)(b) requires the public protector to report on that conduct. And there you can see in the judgment that conduct is being emphasized in the inverted commas. That is the conduct that has been investigated. Section 182(1)(c) empowers the public protector to take appropriate remedial action and says the judgment there. Interpreted contextually and purposefully, the latter provision means that the public protector may take such action as is appropriate to remedy the improper conduct. So it is loud and clear that a remedial action must be one that is aimed at remedying the improper conduct. So the finding of impropriety must be ahead of any exercise of a remedial action. The argument was you don't need to take a 1, 2, 3 stage. You can just investigate partially and still have the ability to take a remedial action on a conduct you have not even found to be improper. We ask again, please give us an authority for that proposition. That the public protector has the remedial power on a conduct she has either not investigated or partially investigated, on which she has made no factual findings, but it is a findings that there has been an improper conduct. Well, let me read it again. It says there, Section 182(1)(c) empowers the public protector to take appropriate remedial action. Interpreted contextually and purposefully, the latter provision means that the public protector may take such action as is appropriate to remedy the improper conduct she has found to be committed in state affairs or in the public administration. That's the only time she has that power under Section 182(1)(c). Judge President and Justices, you have not been pointed to anything that suggests this judgment is wrong.
The Murphy judgment.
I beg?
The Murphy judgment.
Yes.
I think it was put into context as to what it was addressing, that
Yes.
judgment. That
Yes.
it was addressing a public protector who made or recommended remedial action on what had not been referred to her.
That's one of the grounds.
Yes.
But let us go and look at what is said in...
In fact, the other one was that she prescribed remedial action to Parliament to say, you have the power to make legislation, but this is the legislation you're going to make. Those two issues in that judgment. Yeah.
We read it somewhat
Differently.
different, Judge President.
Yes.
Firstly, he says, you can't tell Parliament what to do. You can't tell them to go and amend the Constitution. And these are the reasons why you can't do it.
Yeah.
Now, at the very commencement of that statement, if you can't go and tell Parliament, it is worse that you even tell them what to do. Because we remember, in that matter, she has said, Parliament, you must amend the Constitution. And then she goes on with this aberration and says, you must even do it this way. Let us see what this remedial action says. It then says, you, Mr. President, you must exercise your power to appoint a commission. And then she says, on this following basis, the two are squarely with one another. Why they want to make a distinction in relation to the mandate of the Reserve Bank, it's not the point we're making. We're making a different point. Could she say to Parliament to amend the Constitution, assuming she had stopped there? Would that remedial action have been competent? We ask the question rhetorically. Our submission is it would not have been competent for her to do so. And it is no different even with the judgment of His Lordship, Mr. Justice Murphy. We are also told that the President has already made a decision to appoint a Commission of Inquiry, and therefore he must be told to do so. Why we are told it's because he has already made that decision. Well, the only decision the President is able to make is in terms of the Constitution, and I invite the Court to go to Section 101 of the Constitution and see what type of decision a President can make. The section reads, a decision by the President must be in writing if it is A, is taken in terms of legislation, or B, has legal consequences. That's what a decision of a President must look like. You don't source it from Hansard, or you don't source it from a press statement that has been issued by the Office of the Presidency. That's not a decision of the President. It must have the characteristics that the Constitution says a decision of the President must have. We are also told that he is functus officio. Well, I don't think that requires a reply, really. And we are also told in another context that the Court must find that the President has failed to discharge his onus of showing that the remedial action is irrational, that it is not effective, etc.
Do you mind if I just take you back to the point you've just stepped
Okay.
off from about the functus officio part and him having made a decision? The submissions were that it is only one commission the President is talking about there. It is the commission that is recommended by the Public Protector. And that submission relies on the fact that that statement by the President came after the Public Protector had issued her report. So that's where the spectre of a commission first saw daylight. What's your response to that?
No, that is correct, but it ought to be looked at even in its context.
Yes.
You don't denude the context purely to come to that, Judge President.
Yes.
The context is also that it is set with this review application in place.
Yes.
So she's not saying, I want to implement the commission that the Public Protector says I must implement.
Yeah.
That must be a full square answer to that question. It may very well be that the other context is he has made it plain that I will do that once this review application has been settled. Because if he was to do it differently, as the Judge President indicated, he would be challenged. To say you have not implemented a remedial action which is binding in law, and you can't ignore it until such time as it has been set aside by a court of law.
Yeah.
But the third answer to that question is the Section 101
Yes.
answer.
Yes.
A president's decision must have certain qualities to it that the Constitution enjoys,
Yes.
not a statement in Hansard.
Okay. Can we just go back a bit? I think you've covered this ground already, but I just want to hear what you have to say. I think the argument on behalf of the third respondent, I think also on behalf of the fourth and fifth and the sixth respondent, was sharply put that this power of the President is not unconstrained. And this remedial action is that constraining element to say you can't just sit and decide, I've looked at this, I don't think this is in the public concern, I'm not going to do it.
Again, I want to remind ourselves.
Yes.
This application has nothing to do with the conduct of the president.
But it's a case made out against the president who says no one can dictate to me how I should exercise my power.
Well, the question.
And they are saying no one is making the decision for you. You are called to exercise that power, but under these parameters. Yes.
And I would say to the court with respect,
Yes.
let us go look at these papers where that case is made out. A case which is made out to say, you, Mr. President, you don't have untrammeled power,
Yes.
and therefore we must show you that you don't have untrammeled power. There is no such an application. Good as that argument may be, it is not on the papers. This court is not invited to determine that point. And it was made quite elaborately by the various parties. We need a notice of motion that says, Mr. President, you are wrong if you think that your powers are untrammeled. And we want a court order to that effect, that your powers are not untrammeled. That's an application on another day, on another occasion, and maybe for a different court.
So it's not a competent ground of opposition to a president who says,
No.
I have this power, and this power is untrammeled. And they say, no, we don't agree with you.
Yes. On another court, we might have that debate.
Yeah.
On this one,
Yes.
we are reviewing the conduct of the public protector. It's either the review is good
Yes.
or it's bad. It is not that case, and I don't hold a brief
Yes.
to argue that one.
Okay.
I probably need some papers and a brief and a whole host of supportive issues to come and debate that point.
Yes.
For now, I must emphasize that it is the legality of the remedial action which is before you. Nothing else.
So we should take your response to that argument to be, that's not before us.
And that's not before you. And together with another argument allied to that, the argument allied to that is that the public outcry is there. State capture is an important, serious issue on the constitutional health of this country.
Yes.
It is an important issue on the fiscus of this country, the economy. There is outright public outrage about it. It is urgent. All of those things may be very well good.
Yeah.
Where's the application for it? We have not been shown any application, and we have definitely not come before this court to answer to that case. To this court, we are asking, is the public protector having any power in law, either constitutionally?
Yes. So your argument is simply an ultra-virus argument.
One, ultra-virus, as broad as saying, to be constitutionally impermissible.
That's not the case.
Because you derive your
Absence
power.
of power.
Yes.
Absence of source of
Yes.
power.
And that's the only basis of our attack. We say we don't have the authority in law, and even the nature of what a remedial action looks like goes outside the doctrine of separation of powers. That's the argument. And if we are good on that, that's enough. If we are bad on that, then we must fall.
Can I just tackle something? Just on the comment you've just made. You say, if you're bad, then you must fall. Then what?
Then it means the remedial action is not suffering any constitutional deficit. It must be implemented.
Okay.
But if you cannot point us to any source in law
Yes.
that enables her to do it, then the review is good. And we have attempted to look at what source in law she has or has been claimed on her behalf
Yes.
for the remedial action, and we cannot find it. Oh, I was touching on a different point about.
Sorry. Apologize for interrupting you.
Yes.
I apologize for interrupting you.
Oh, no, not a problem at all. Mr. Mpofu tells us that part of the reason this court must make is that it must find that the president has failed to discharge an onus because he has not shown that the remedial action is not effective or appropriate or rational. Now, Justices, we must remember, questions of onus are in trials. You can't talk about an onus in motion proceedings. So it's just simply bad. How can you have an onus to prove beyond probabilities and beyond reasonable doubt? All those things belong in trials. They don't belong here, and I'll give authority for that proposition if I have to. Since the days of Plascon, we know how a relief in motion proceedings is obtained. You take that which the applicant says and that which the respondent has admitted and to ask yourself, does it vindicate the relief? That's what happens in motion proceedings. We don't talk in onus. The authority for the proposition which we are making is plain, but it is a South African law of evidence by Zeffert, and it is page 180, and it quotes there in the middle, motion proceedings, comma, unless consent with interim relief, are all about a resolution of legal issues based on common cause facts. The other authority, if one was ever needed, is what Mr. Mpofu referred to, which is Hoekstra. But I think the right passage there is, page rather, is 543. Mr. Mpofu would have given us a different page.
543.
543.
Are you referring
No, Hoekstra now.
Hoekstra.
Yes, Administrative Law in South Africa. That's the book Mr. Mpofu referred us to. Generally speaking, criminal cases require facts to be proved by the state, open quotes, beyond reasonable doubt, whereas civil cases merely require proof, open quotes, on a balance of probabilities, or open quotes, on a preponderance of probability. These are trial matters. There were instances where we address a different point about the investigative powers of the public protector. Now, a reading of that act will tell us the word investigation is used and the word provisional investigation, the phrase provisional investigation is also used. Can I invite us to go look at that act again, but this time to go and look at section 7. Section 1 says the public protector shall have the power on his or her own initiative or on receipt of a complaint or an allegation or on the ground of information that has come to his or her knowledge which points to conduct such as referred to in section 6, 4 or 5 of this act to conduct a preliminary investigation for the purpose of determining the merits of the complaint. You can only do a provisional investigation for the purposes of determining whether a particular complaint has merit. Not where you say, I know this complaint has merit, I'm not going to investigate it, but I'd rather have somebody else do it because maybe they don't suffer the budgetary constraints that I suffer. And then comes the section 182, power. And just to bring us back, I think it is important we look closely at what this section says. (182) (1). The Public Protector has the power, as regulated by national legislation, to investigate any conduct in state affairs. So, if we pause there for a moment and say, we know now she has the power to investigate. She must investigate any conduct in state affairs or in the public administration in any sphere of government. What conduct? Conduct that is alleged or suspected to be improper or to result in any impropriety or prejudice. So that's the first hurdle she must do, is to investigate. But what would be the purpose of an investigation if that investigation is not intended to come to a finding that said that conduct is improper?
She has to report that conduct.
Before
What does it mean to report that conduct?
Before we come there, Justice Borokhovitz, it must be plain on 182(1)(a) firstly, because the report is B. I'll come to B. But at a level of A, she can't be investigating for investigative sake. She must investigate whether the conduct complained about or suspected to be improper indeed has been found to be improper. Otherwise, there's no point in investigating if it is not to establish the merits.
Aren't you placing that too highly? That she has to find that there indeed is improper or prejudicial conduct.
Then the rhetorical question
I'm
becomes,
talking about in terms of the language used in this 182(1)(a).
it is not putting it any higher, because when you exercise the remedial power, it must be to cure that improper conduct.
Why do they use the word, that's why I moved to B, to report that conduct? What does it mean to report on that conduct? Report.
There is
It doesn't say to make findings, to report, and to the next step is to take appropriate action.
Yes. Firstly, the entire focus is to investigate a particular conduct. What type of conduct? A conduct that is prejudicial or a conduct that is improper. That's what you must investigate. And then says you can report on that conduct. What conduct? The conduct that has been found to be improper or resulting in prejudice.
No, it's the conduct which is alleged to be improper.
No.
I'm sorry, I'm taking a literal interpretation of what I read there.
Yes. Okay, let me test whether or not that reading would be consistent with the language of the document, of the Constitution. Is it consistent?
Literal approach, not without regard to values and just what it says, the language.
Yes. Let me state it this way, Justice Borokhovitz. Assuming the investigation reveals that there is no improper conduct, or there is no conduct which results in any prejudice, assuming that's the scenario I'm painting, can a report be made under B? Clearly, the rhetorical answer is no. You can't make a report and then take remedial action on a conduct that has not been found to constitute a misconduct. I mean,
But Mr. Simeone, sorry to interrupt. I think if we look at 182(1)(a), it says clearly to investigate any conduct in state affairs that is alleged or suspected. It's even lower. So it's not that the conduct has been proven, it's alleged, or there's a suspicion.
No, it's the complaint which is alleged. It is the suspicion which she must investigate.
But when you read it, it doesn't say the complaint, it says any conduct.
No, sorry. Sorry, Justice Hughes, I meant to say something different.
Oh, sorry.
I meant to say what it says is it is to investigate the allegation of impropriety. It is to investigate the allegation of misconduct, of impropriety, or which is suspected to be improper. That is what you must investigate. But having investigated it, you surely must find that the complaint has merit, and you must report on that conduct. There is no other way of reading this with respect other than to say the power to investigate are to investigate any and everything. Yeah. Whether the allegation is sound or not, whether the impropriety is only suspected. So what it says is, if I suspect that there is some impropriety happening at the National Treasury, this section says, and I lodge that complaint with her, this section says she must investigate that suspicion. It doesn't say you must report on the suspicion. It is investigate to find out whether there is impropriety in that suspicion found. It is an investigation to determine whether any prejudice has resulted from that conduct, and then you must report on it. But having reported it, then you have the remedial action to say, I want to correct that impropriety. That's why you cannot have a remedial action if you found the conduct to be proper. And let us look at what Section 8 of the Public Protector's Act says. Under 8.1 it says, the Public Protector may, subject to the provisions of subsection 3, in the manner he or she deems fit, make known to any person any finding, point of view, or recommendation in respect of a matter investigated by him or her. 2A, the Public Protector shall report in writing on the activities of his office or her office to the National Assembly at least once every year, provided that any report shall also be tabled in the National Council of Provinces. 8.2b, the Public Protector shall at any time submit a report to the National Assembly on the findings of a particular investigation. That's what she reports about. She must report on findings. She can't report on suspicions. She can't report on allegations. She must report on those findings. So in this case, what findings is this remedial action reporting on? If she was to table this report before Parliament, she'll say she has investigated what? If she's to table this report before Parliament, she'll say she has made which findings? And that is what Justice Gorohovitz will say is meant by report on that finding under B. Report on that conduct under B. So she can't, as we have been told, without any investigation or with partial investigation, I think this is what was said on behalf of the Public Protector. Because of partial investigation, she still has and can have the power to report and table this type of report that says I made no findings. That can't be so. I cannot sit down until I bring us back to what was said by the Public Protector herself in the affidavit and in the heads of argument. We find that on page 73 of the pleadings bundle, against paragraph 29. The public protector says, I accept that it will almost always be impermissible for the public protector to require the president to appoint a commission of inquiry or to determine the mode of operation of a judicial commission of inquiry. So it's clear in her mind, she knows. Ordinarily, I don't have these powers. But then cites what she says are exceptions to the rule. And the exception is that I don't have adequate resources. Can that ever give a public protector a power she doesn't have in law? And then the second one, it says, well, Mr. President, you are implicated in these allegations. How can that then clothe her with a power in law simply because the president is conflicted? We are still struggling to find the source of authority for what she says she is doing.
I'm sorry, I don't know if it's convenient. Before you deal with this, we're talking about the ultra vires argument. What does subsection 182.2 mean when it says that the public protector has the additional powers prescribed by national legislation? Doesn't this an indication that this is the empowering section under the Constitution, section 182, but additional to that, she has the powers set out. So they're supplementary powers. And therefore, when one looks, they're not intended to be limited. The source of power is the section.
Yes. But
I'm looking at the word additional powers.
The word
additional powers.
The word additional powers, Justice Berochovitz, is that which is explained in Section 7 of the Public Protectors Act. That national legislation in 182.2 is exactly the Public Protector Act. And when we go to 7, in fact, if you go to Section 6, it then deals with reporting matters to an additional powers of public protector. And none of the 6, we have dealt with 6.4, we have dealt with this and dealt with the other, gives the public protector the power to instruct or compel the president to do something that only the president can do. The other argument which was offered by my learned colleague, Mr. Badlander, was...
Sorry, Mr. Selina. In respect of additional powers, the court has dealt with what constitutes additional powers, and that was in the latest EFF case, I think paragraph 61, to be exact. And doesn't that fall within the realm of the explanation given by the Chief Justice in that case? Paragraph 61. Which is at page 69 of the President's bundle.
Well, the judgment reads, Section 182.2 envisages, open quotes, additional, close quotes, but certainly not, open quotes, substitutionary powers. It contemplates additional powers and functions. Giving the word additional its ordinary grammatical meaning, it means extra or more or over and above. Nothing but additional in this context could ever be reasonably understood to suggest the removal or limitation of the constitutional power. A reading of Section 6 of the Public Protector Act bears this out. The Public Protector Act did not purport to, nor could it validly denude the Public Protector or her constitutional powers. On the contrary, and by way of example, Section 6.4a, Roman figure 3 and Roman figure 4 adds expressly unlawful enrichment or corruption to powers and functions she already has. The power to investigate institutions in which the state is the majority or controlling shareholder, undue delay, unfair and discourteous conduct have also been added to the investigative powers of the Public Protector. We take no issue with that. The issue we take is whether those additional powers include her right to trample on the separation of powers doctrine. And this judgment is not giving her those powers either. The argument is raised again that, and this is what my learned colleague, Mr. Badlander, was making. But he made it with qualification. He says, I'm not saying the one is the same as the other, but I'm saying that the approach by the Constitutional Court is instructive for you to almost pair the power of the Public Protector with those of a court. That's as high as you could take it. But let's examine that argument again. As is said in many judgments, not even courts have the power to cross the line. Everybody must stay in their lane unless they are mandated by the Constitution to do so. And I think this is the argument which Mr. Gotts also has made. He says a dictation would be a dictation if it is unwarranted, but if it is authorized, I thought that the argument was, then you can cross the line. Well, we know when we look at 172 of the Constitution, and I will address the Hoër School judgment later. We know that 172 authorizes the courts to give appropriate relief in questions that raise constitutional disputes. That we accept. But it is because the courts are authorized to do it. But even in doing so, the courts cannot exercise the powers of the executive to which they are investigating, they are adjudicating. Even in the EFF judgment, the UDM judgment, the court stopped short and said, we are going to leave the power to decide what vote must happen on the Speaker. Won't go further than that. And we say if these two are of equal power, what is the authority for that proposition? Mr. Badlander did not give us an authority for it. He just says it is like a power as the court would have under 172, the power to make a remedial action. We ask again, as loud as we can, where is it? What is the authority for that proposition? We did not get any. The draft order. One would have thought there was an application which the draft order is going to be answering to. Now you have a draft order by a respondent completely unrelated to the notice of motion before the court. It's just baffling.
But isn't this court permitted to grant, if it exceeds to your, well, if it does not exceed to your application? Does the court not have discretion to fashion a remedial interdict of any sort?
Well, two things. Firstly, the court has the power to dismiss the application.
Yeah.
And we submit, once the application is dismissed, it means the remedial order is in place, it must be complied with.
But we're in a situation now, are we not, where time, the passage of time has caused a problem. We're not confronted with a situation when the report was issued in April of 2016.
October 2016.
October 2016.
The structural remedy, I have no difficulties with it, that courts do have the power to do it. But let us look at what this draft order tells us. It says this court can order, one, the application can be dismissed, and we are in agreement. If we have no merit, that's an appropriate order that can be made. The remedial action taken by the Public Protector against President Jacob Zuma in terms of Section 182(1)(c) of the Constitution is binding. Firstly, this issue is not before this court. And there has not been any contestation that the remedial action is binding by a public protector. So it resolves which issue, which dispute in these proceedings. 3, the failure by the President to comply with the remedial action taken against him by the public protector in a report of titled, and then it is described, is inconsistent with Section 83B of the Constitution, read with Section 181(3) and 182(1)(c) of the Constitution, and is invalid. Which notice of motion is talking about those things? There is no counter-application here. And certainly we would have filed papers and we would have dealt with that issue if we anticipated remotely that such an order would be requested or would even be given by court. 4, the Public Protector is to deliver this order to the Chief Justice no later than 5 days of this order. Where is the notice of motion for this? And I can understand structural relief. I have no difficulties with that. But make out a case for that structural relief to obtain. And let us meet the type of case. And then let us argue it. And let the court make a finding of it. You just don't get given this during argument. 5, the President is to appoint within 15 days of this order a commission of inquiry headed by a judge solely selected by the Chief Justice, who shall provide one name to the President within 5 days after receipt of a copy of this order as above. But that's what the remedial action says he must do, except the altering of the number of days.
The time limits have become exhausted.
Yes. But where is this notice of motion? Where is this on affidavit? And what's the explanation offered for it? And have we met that or haven't we met it? If the court says we have sufficient basis to structure a relief that can deal with the passage of time, I have no difficulties with it. The President is further directed to comply with para 8.7 and 8.8 of the Public Protector's report in that, and then it tabulates them. I think lastly what we want to say on this point is certainly a proper case has to be made out why a structural relief is being sought. It can't just be made in abstract and not even offering us an opportunity to know these are the reasons and this is the case made out for it. We did not hear Mr. Maleka argue the counter-application with gusto as he did the other elements of of the Public Protector's case. And we give the Subrumani judgment as an answer to that. That questions of appropriations are questions reserved by Section 44 and 45 to Parliament. A court can therefore, without straddling the separation of powers again, then says, Mr. President, you must do it. But the language of the counter application is also interesting because it does not tell us in law where can the president source the power to ensure that an appropriation of a particular kind happens. And if he fails to ensure it, then probably be in contempt of court. So there is not even sufficient specificity to say, Mr. President, under the Constitution or this law, you are able to ensure that appropriate allocation of funds is made. It is a power that Parliament can only make. And to invite the court to say it must say so to the President would, in our submission, be impermissible.
Is it possible to understand the counter application to mean, Mr. President, you are the first citizen. You have the responsibility, constitutional responsibility, to assist constitutional institutions such as the Public Protector. In keeping with that responsibility, stroke obligation, do something. Can one understand the counter in that sense?
No.
We can't.
No. It can be understood to say the president, let me state it differently. If the president says, I have an obligation towards the poor, it's an obligation that I have. They are in distress. I'm going to appropriate money to address the conditions of the poor. We would be the first ones to say, no, you don't have such a power. It may be a good and wonderful thing to do. It may be politically correct, but you don't have the legal power to do it. Ultimately does the president have that? Whether good intentioned or otherwise, does he have the power under the constitution of the law to say so?
I think I use the word assist.
Okay.
Yeah, because I think what it implicates is it not possible for him as the head of the executive to say we need to assist that constitutional institution to speak to the relevant departments, National Treasury, for instance. I'm just posing it. I'm saying, can one not understand the counter application in that sense?
That the president has a duty in law to tell Parliament to assist a particular cause.
When I say assist,
Yes.
I say assist.
That's the word I'm using,
Yes.
Judge President. I'm using exactly that.
Yes.
Then I'm bringing the question in my head.
Yes.
Does he have in law a power to tell Parliament to assist where he thinks they must assist with appropriation? Or to tell Treasury, please go assist. There's a need there.
Can he not say, please consider assisting? He's
Well,
not imposing anything, but he's saying, this is a constitutional institution that is in distress. Is there anything you can do to assist? That's why I use the word assist advisedly.
Okay. Assuming that order, the counter application is granted,
Yes.
in what respect can we find him to be in contempt of that order? What assistance are we asking him to do? Just to write a letter or to drop a voice in the ear of the Minister Gigaba, or to do what? That's the difficulty in formulating the relief as is formulated by the Public Protector.
So your response is the counter is a non-starter.
It can't go beyond the base one at all.
What about the provision in 1813 of the Constitution?
It must mean that they have the obligation, other organs of state, it reads, through legislative and other measures, must assist and protect this institution to ensure the independence, impartiality, dignity, and effectiveness of these institutions.
Yes.
Within their powers, they must do that. They can't do it because they want to assist by exercising a power they don't have in law.
So this section with the subsection won't come to the assistance of the President?
Not at all. The President has an obligation to assist, but he can only assist within the meaning of the law. He can perform no function or exercise any power unless that which is authorized by law or the Constitution. BioWatch. Can we go to paragraph 21 of the judgment? I don't think we have it before court, but I will read it. BioWatch should not be abused. It does not arise simply because there's a constitutional matter before court. BioWatch is seeking to protect those people who want to vindicate a constitutional right. None of these respondents here are seeking to vindicate any constitutional right. If there were, BioWatch should apply. But if there is no constitutional right they're seeking to vindicate, then it means that the costs follow the result. And that contention we cover in the replying affidavit, paragraph 18, page 438. The Hoërskool Ermelo judgment, the judgment of the former Deputy Chief Justice, where it indicates that there does not have to be a connection necessarily between 172.1 and the appropriate relief that is indicated there. It still remains a far cry to then take the powers of a court under 172 and equate them to a remedial action a public protector can take. There are a whole host of things courts do under various statutes and in their inherent powers, and they do those. But you can't say the same exists for a public protector under the Constitution or the law. And again we ask, where is the authority that the public protector can do that? Because the powers of the courts we know exist and they are in the Constitution, they are in various statutes. The question of rationality again, we must ask the question pointedly. Is it enough when the Parliament says you must investigate maladministration, corruption, and a whole host of other things to say, well, I'm not going to do that because I have no adequate funding? Is that rational? then the police must not do their work because they have not adequate funding. Then courts must not do their work because they don't have adequate funding. Then any other functionary whose duty it is to do what the parliament says they must do, they would find it sufficient escape to say, I can't do it because I don't have the money to do it. No, on the contrary, if the problem is money, you go to parliament and you say, I need a special appropriation to discharge my constitutional duty. And if parliament, despite compelling case being made for it, rejects such an application, then you can come to court and say, parliament has violated the constitution with this refusal. I want that refusal to be set aside. It's a completely different trajectory that you then take in those circumstances. Mr. Maleka also argued that we must look at the language of 84. (84) 2F. And I think the emphasis he made was on the point the president is responsible for, and say, read duty there. That he has the duty to appoint a commission of inquiry if the circumstances for the exercise of that duty is shown to exist. Again, where is that notice of motion which says, Mr. President, you are now ordered to appoint a commission of inquiry because objectively, and even you agree, there are sufficient grounds for you to exercise that duty. Again, we may come to another court on a different date if there is such an application serving before the court. There isn't, simply. And why do we say that? We still rely on the Daniel judgment, and in particular paragraph 12, where, as we say, the court there dealt with the exclusive jurisdiction of the Constitutional Court, but also dealt with this very power and said it is not a duty, it is in fact a power. So that to us would be of sufficient authority for the proposition that what appears in section 84 2F is also consistent with a Sarfu judgment that it is a power only the president can exercise. It doesn't say it is a duty that the president has to exercise under certain circumstances. And no authority has ever been offered for that proposition. Those are the arguments we make in reply, Judge President and Justices.
Advocate Semenya, I just want to understand the President's case. And in the light of the relief he seeks in the amended notice of motion, he says, set aside this remedial action for the reasons you've advanced. And he says, remit the matter to the Public Protector for further investigation. Is he serious in seeking that relief? The remittal.
Judge President, serious to connote that
Let me explain why, maybe. Maybe you'll tell us what view we take of his utterances in Parliament, where he says we've taken a decision to appoint a commission of inquiry. If that's serious, that's seriously stated in that governing body of South Africa, what do we take of the relief he seeks, that send it back? Does it presuppose that send it back and I'll continue sitting back and doing nothing?
No, I understand it squarely. No. That relief, we can't persist with it, of the remittal. It must mean he probably will act on his undertaking, alternatively will be made to act on his undertaking in different settings.
And you persist with your costs order that if we're with you, you want your costs. You say BioWatch has no application here.
BioWatch, there's no application.
Thank you, Advocate Suminya.
As the court pleases.
Thank you. Advocate Maleka, you have a right to reply. I'm told you didn't argue your counter application with gusto as you argued the other points of the matter. Do you have a reply?
Yes, I have a few points to make.
Yes.
I won't detain the court because it's too late in the day. As we understand the final submissions of our learned friends on the counter application,
Yes.
they are based on a rhetorical question around where does the president get money to resource the public protector
Yes.
to undertake the very investigation that he claims to be serious of. Well, the rhetorical argument by learned friends do not engage with the terms of the public protector's conditional counter application. And I would ask the court to look at the notice of conditional counter application, which is on page 450 of the pleadings bundle. On page 450, the court will be interested to note the formulation of the notice of motion. And there will be debate as between our learned friends about whether some of the arguments that have been advanced in the main application were accompanied by a notice of motion to justify the relief sought in the draft order. So we've gone past that debate. But look at the terms of the conditional counter application on page 450. One, if this court sets aside paragraph 8.4 of the remedial actions in terms of prayer 1.1 of the notice of motion and remits the matter to the public protector for further investigation in terms of paragraph 1.2 of the notice of motion, the president is directed to ensure, and that is the auxiliary verb which is quite important, to ensure that the public protector is provided with sufficient funding to conduct the second phase of the investigation. So that the formulation of that prayer is not that the president himself must find money, but he must do something within his power to ensure that the public protector is adequately resourced. Our learned friends ask rhetorically, but where is the authority for that prayer?
Can I just pose something to you? I was under the impression that the counter application was based on the remittal relief the president was seeking. That is gone. Mr. Advocate Suminya has told us the president is no longer persisting with the remittal relief that he sought. Is the public protector still persisting with the counter application?
We have misunderstood his response to the court. If he says that the president no longer persists
Yes.
with the prayer that the investigation must be remitted
Yes.
to the public protector,
Yes.
because of what he said in Parliament, then we will not persist with the conditional constitution. What remains is whether or not the Public Protector has identified the source of her power to call for the Commission of Inquiry.
But that's in the main matter.
That's in the main matter.
So I'm saying we're now in the conditional application realm. And Advocate Semenya said the President is no longer persisting with the remittal relief. I'm saying, was I incorrect to understand that the counter application was premised on that?
Not at all, you were correct. And therefore, there will no longer be a debate about the counter application. If our Leonard Friend is correct in conveying to the court that the President no longer seeks a remittal, there may be questions of the costs relating to the counter application. I leave it to the court to decide the question of the costs relating to the conditional counter application.
Yeah. I think Advocate Semenya was clear that if the President loses, then the remedial action is legit. Am I correct, Advocate Semenya?
That is so.
Yes. So I think that takes care of the counter application.
Indeed. Then I'll make no further submissions. That is the point.
Yes. I think that brings us to the end of the matter. You're still on your feet, Advocate Maleta.
I'm just conferring with my Leonard Friend here. My Leonard Friend wants me to convey to the court that the court must consider a possibility where it simply sets aside the remedial provisions of the Public Protector Thuli, but does not remit the matter back to the Public Protector. If the court were to be so inclined, then the Public Protector will be hindered because she will be seized with the matter that require further investigation, without the necessary resources that require in terms of the conditional counsel. So it is vital for the court to consider the implication of the order that was made if at the end of the day it finds the contentions of the President to be well founded. And that's a simple point I've asked the court to consider. But I make no further submissions.
Judge President, with your leave.
You don't have any airtime.
I know I don't, Judge President. We've had an abandonment at the last moment, in literally the last seconds of our Leonard Friend's address, of a fundamental part of the relief that he seeks. And with respect, we are entitled to be heard on why that means that his case is untenable. His abandonment makes his case untenable because what he suggests, if I may be permitted to address the court for.
Maybe you must tell me what you suggest should happen as a result of this, you call it the abandonment of relief, yeah. What you suggest we should do in the light of thereof.
What I submit the court should do is that it demonstrates that the court has to dismiss the application as a whole, because the President's own case puts the court and my client, which was a complainant, and indeed the country in an intolerable position. Because the effect of his submission now is that the court should review and set aside the Public Protector's report and the remedial action which refers it to a commission. The court may not remit it back to the Public Protector because he doesn't seek it. And instead, this is because there will be a commission appointed by him, presumably including a judge picked by him, in circumstances where the court has heard no cogent argument from the President with respect as to how that could be a constitutionally permissible state of affairs. You've heard detailed argument from all of the respondents about how it could never be constitutionally permissible to have a judge picked by the President to head a commission which is investigating him and his family. And yet that is the very effect of the relief and case now advanced by the President. So we submit that the abandonment is noted. The fact that it comes at the last moment is deeply regrettable, but it is noted. But it makes the President's case on his primary relief equally untenable, because it would leave the court and the complainants and the country in a position with no adequate remedy. They can't get a remedy from the Public Protector because it's reviewed and set aside with no remittal. They can't get a remedy from the President because the only remedy the President offered is that he will pick the Commission and he will do it. And what that means is it demonstrates the untenability of his main submission. And that's all I wish to say in light of that last minute change of mind. And I'm indebted to the Court for the indulgence.
Thank you very much. I don't think I see a lot of movement in court. Advocate Semenya, you've unleashed something here.
But I haven't, my lord.
You
with
haven't,
respect.
okay.
No, I haven't. If the application of the President is good,
Yes,
it means that remedial action of commissions and things were wrong.
you're right.
How can it be leaving anybody in limbo?
Well, I think the issue, Advocate Semenya, is the President agrees with everyone sitting here that this is a matter of national importance. It's in the public interest. Now, the issue that arises is he came here, he said, no one can dictate to me. And the Public Protector can never have the power to dictate to me and tell me how to do these things. So if he wins, and that's the concern here,
If he
if
wins,
he wins, that means the remedial action is set aside. What then?
two things, Judge President.
Yes,
He can say, I'm appointing a commission of inquiry, and I'm going to appoint a judge selected by the Chief Justice to preside over it, because I want to remove the spell that I am conflicted and therefore choosing a particular judge for my own ends. What if he does that? What would be the complaint?
is that a factor we should record formally placed before us, that if he wins, that's what he's going to do, so that we can consider putting it in our order?
No, when I don't have any instruction on that. On that point, I was answering what could then happen. I
Yes.
said two things may very well happen. And it may very well be that the President says, I'm appointing just so-and-so, and these are the terms of reference, and we find nothing wrong with the terms of reference. And then the applicant will come to court and say, not you, because you are conflicted. And then we'll hear that case when that happens. So I've covered both ends.
Yeah.
If he acts
But
consistent...
we're left with nothing. We're in limbo. If the President wins, because the remittal was a necessary leg to the relief he sought, so set this aside, let it go back.
No. We could have proceeded with the review and setting aside alone. And if we are good in law that it
Yes.
stands to be removed, reviewed, because she has no power, that's
Yes.
the end of it.
Right.
What happens subsequently, let's measure it on its terms.
Yes.
Yes. We did not need that prayer for the first prayer.
Well, I think just to avoid, because I see a lot of people are eager to jump up and talk to us, would it be unfair, because people want to address the court on this, to say, I can invite argument, because that's what people want to do, like Advocate Butland has done, but only on this restricted point. And it should be written argument. I don't want oral argument.
I would not resist, we would not resist that, GP.
Right. Is that acceptable? Advocate Mpofu? You're not making submissions. You're responding to what I'm saying.
No, I'm not, JP. I simply want to stress why this really throws the spanner in the works. Firstly, just on the narrow question, I agree, JP, that there should be those submissions, and maybe there's no time now to make them here. But could they be really done on a very, very, very limited time basis?
That's what I've said.
Because we don't want to have another merry-go-round, with the greatest respect. Because we now have a situation where if the President wins, he says he might either do one of two things. either appoint, let's call it Commission A, which is the one that the Public Protector wants, or Commission B, which is the one where the Chief Justice does not select the judge. They told us yesterday that if they do Commission B, there's going to be another court application, which is true, I can guarantee that. But so exactly, we're now going to be dragged on for another 2 years with the greatest respect. And
But doesn't the suggested solution deal with that issue? To say, give us further submissions on the retraction of the remittal
its
relief.
implications.
Yeah.
As soon as possible.
Yeah,
That's
and
correct.
I think it's only fair because Advocate Siminya, I probably caught him off guard, but it's my responsibility to check what's the relief based on what we've heard.
I've
Right.
done some sign language with my colleagues. A quick check, that would be acceptable, Judge President.
Yeah, because what I was saying, I think it should be written submission within the next 5 days
That's correct.
by the respondents who are minded to make those written, and the president, if he's minded to respond within 3 days thereafter.
That's
Would
correct.
that be acceptable?
That would be acceptable.
Okay.
That's acceptable to us. Let's go, please.
Okay. Okay, I think
Just once again.
you want to say something, Advocate?
No,
Wait a-
Judge President, I actually think my concerns can be catered for elsewhere. Perhaps I should say that because I see now I've got the attention. the only two things I wanted to say, Judge President, is that the extent of the relief, it would be much preferable that the court itself sets out the directive of the extent of the ambit of what we are to address, so as to avoid disputes about precisely what has been opened as a consequence of this. I'm thinking, for instance, the Public Protector has told us that she has no resources to conduct an investigation on her own. So the idea that the remedial action would be set aside, but then there would be no further action. And the President, it's not clear whether or not he wants to appoint a new Commission of Inquiry. So it seems to us that the most practical thing to cater for Mr. Badlender's useful suggestion is the court itself to set out the parameters of what we are to address in the remedial action, in the supplementary submissions in the light of the concession. I have my suggestion about how that should look like, but I'd rather not make it because that itself might invite further arguments.
But I thought it's just the implication of the retraction of the remittal relief.
Yes, that is true.
Yes.
But my concern about leaving it open to us is it could be possible that it would be differently interpreted. Because one of the concerns I have certainly for my client is what is the position in relation to the further investigation? Is this a further investigation to be done by the Public Protector? Or is the President's commitment to the court, because we also don't have that, is the President's commitment to the court that he will in fact appoint a Commission of Inquiry? And if so, on what terms and when? And if he says he will appoint a Commission of Inquiry, what is his suggestion in relation to the appointment of the judge, which is the major sticking point to the case? And unless we know what the commitment of the President is going to be on those key questions, we might, as Mr. Mpofu says, ultimately simply begin another merry-go-round and a fight about precisely what is the ambit and the parameters of the supplementary submissions. So it seems to us that in the light of the concerns about the urgency of the matter, it would be much helpful, and I'll take it no further than that, much helpful for the court itself to prescribe to us what is it exactly that we should be addressing. Especially because the President has made no commitment about how he sees the future. Is he going to appoint a commission in the light of what he said to Parliament? Is he going to appoint the commission in the light of what the Public Protector said? Is he going to appoint a commission similar to what the Public Protector has said? Those questions, I respectfully submit, are vital to our suggestions that we can make about how the court should deal with the failure, sorry, not with the absence of the remittal to the Public Protector. Yes, Mr. Mpofu simply adds that the draft order was necessary for that reason.
I have just conferred with my colleagues. We are suggesting that we adjourn for the moment. We go into the judges' common room and we invite the legal teams to join us. Then we'll come back here and put on record the suggested way forward as far as this matter is concerned.
Is it the palace, JP, is that the palace or here?
No, here.
Here, escort.
I know some people hate walking. Okay, court adjourns momentarily.
No, it's not.